Hello everybody. Today we are going to pick up where we left off last time. We're going to continue the conversation around Rule 702 and expert opinion. So we talked last time about the first three factors on your screen under 702 that require experts to apply reliable principles and methods and to reliably apply those reliable principles and methods to the facts of the case, and then also that evidence has to fit the facts and otherwise be helpful to the fact finder. So we start today with step number 4, which is ensuring that the proffered expert who's going to testify is qualified to testify on the subject matter for which he or she is planning to testify. So Chapter 62 is where we're starting. It picks up with where we left off, and then this lecture is also going to cover chapters 63 and 64, which further relate to expert opinion testimony. So the process of qualifying an individual expert is separate from the reliability issues discussed in the previous chapter. So a witness must qualify individually as an expert and must also offer expert testimony that rests on a reliable method, applies that method reliably, and, as I said, assists the fact finder. So the rule 702 defines qualified witness very broadly. The qualifications don't depend exclusively on educational credentials. Courts have approved experts who have even lacked a high school degree, but they somehow possess relevant other practical experience. Conversely, courts have rejected experts with very impressive resumes, such as experts with educational backgrounds from Harvard or MIT, when their qualifications do not fit the subject matter of their testimony. So there's some examples from your reading. The expert in the business of licensing photography rights, that's the Dyer case. Also the experts in the organization of the Mexican cartel and use of code language, manufacturing, packaging, and distribution of drugs, that's Garcia. So the point is that you don't have to be a doctor or a scientist to be an expert witness, but the expert's qualifications must match the testimony she offers. So to be qualified, you can be qualified by either knowledge, skill, experience, training, or education. So there are 3 basic steps to qualifying a witness as an expert witness in the trial. So the proponent, the person who's offering the expert, is going to want to start by laying a foundation for the expertise by asking questions about the expert's background, education, training, or particular skill set, their credentials, their employment history, and of course, you can use leading questions. Even though normally leading questions are reserved for cross-examination, courts have held when eliciting uncontested background information that attorneys can use leading questions on direct. Be aware that the opponent may voir dire the expert. That simply means ask questions of the expert to try to test the credentials or attempt to show a lack of fit, and at the end of the voir dire, some opponents will formally object to that expert's testimony, and usually the court will overrule the objection, but it's still necessary, right, for the opponent to voir dire and to object in order to preserve that issue for appeal. And then sometimes they don't object. Sometimes at the conclusion of the voir dire, they will agree with the other side that the expert can testify. Finally, the judge, as I sort of alluded to, will rule on the formal motion to certify the witness as an expert witness in a particular matter. So the next slide is from the movie My Cousin Vinny, which we've watched at least 1 or 2 clips before from this movie in class. And this is a good illustration of an attorney putting a potential expert on the stand, and this scene in particular shows the other side. In this case, this is the defense's attorney's expert witness on auto mechanics. And if you'll recall, this is the film where two young men are from New York are caught up in charges for shooting a store clerk, and I think they were taking a vacation or driving through Alabama. They claimed that they didn't do it, that somebody else did it right after them. And there were issues in the trial around tire marks and whether the tire marks of their car matched tire marks left at the scene of the crime. And so Joe Pesci, who played the defense attorney, put his girlfriend, played by Marisa Tomei, on the stand because she had worked, although she, didn't have real extensive education, she had worked with her father growing up, as her father was a mechanic, and he taught her a lot about cars and car engines and tires, and so she had worked in that field. So he proffered her as an expert on automotive issues in general that had come up during the trial. So this scene shows you Marisa Tomei being voir dired by the prosecutor, who's trying to argue that she's not qualified to testify as an expert in automotive mechanics. And remember, again, she has no formal training or education in this field, but she does have a lot of experience working with cars. Ultimately, she is qualified by the court as an expert. During the voir dire, you'll note that the prosecutor tries to test Tomei by asking her a trick question, but she answers the question perfectly. So I can't play this clip for you on this YouTube lecture, but if you go to Top Hat, of course, as always, you'll see all of my slides on Top Hat, and you can go ahead and play the scene and watch it. It's a useful scene to watch on a couple of different levels. First, it emphasizes that an expert need not have any formal training or education, especially in a field like automotive mechanics. The clip is also a good example of some misconceptions that a lot of people have about the voir dire process. And some of those misconceptions are actually encouraged by what took place in this scene of this film. So voir dire usually is not a battle between the two attorneys to try to prove that an expert is sufficiently qualified. The proponent of the witness should already be quite confident that the witness possesses the qualifications, and then there's never this test. So in this scene, the prosecutor asks a trick question, as I alluded to sort of try to test this witness's knowledge about a particular type of vehicle. And that really doesn't happen in real life. Instead, the opposing counsel will merely try to lower the jury's estimation of the expert by tarnishing her credentials in some way, without any real hope of preventing her from being qualified as an expert. So just be aware that those are some misconceptions. Also, keep in mind that the expert's qualifications must match the testimony she offered. And in this particular scene, the government tried to argue that an auto mechanic is not qualified to testify about tire marks, but here the defendant corrected him about the scope of Tomei's proposed testimony and said, he wasn't putting her on the stand to testify about tire marks. So go ahead and watch that one on your own. And right now I'm just trying to skip through this scene. I don't know if it's going to let me. Here, we'll do it this way. So here's an example which varies somewhat the facts in a recent case. So the party in this case wanted to call an expert to testify about what caused a house fire, and in particular, whether the house fire was caused by a flaw in the wiring of the house, or was there some other cause for the fire. So the party presented an electrician to give an expert opinion on this question, and here are the credentials of this proposed expert. He has no high school degree, but had 15 years of experience doing residential wiring and taught classes in residential wiring and consulted with the fire marshal on causes of electrical fires in homes. So this brings us to our first Top Hat question. You'll want to head over to Top Hat now to answer this problem after pausing the YouTube video. The question is this expert I've just described to you or this electrician I just described to you qualified to testify as an expert? Yes or no? Press pause now and then press play for the answer. Okay, so in an actual case with very similar facts, the court held that yes, this particular electrician was qualified to testify as an expert. Now bear in mind that not all trial judges would agree with this finding, so this is an area of the law where advocacy will play a big role. If you can really convince your judge that your particular proposed expert is qualified by background, skill, education, training, expertise, any of those factors under 702. The important point, though, to take away from this particular case is that a formal degree is not necessary to qualify someone to be an expert at trial. Let's do another example. In this case, the plaintiff claimed that his stockbroker turned his commodities futures account. So in plain language, that means that the stockbroker conducted excessive trading that gave the broker commissions but didn't really do much to help the plaintiff out. To show that the trading was excessive, the plaintiff needed an expert. He presented a professor from the Wharton School of Business, and here are this expert's relevant credentials. He has a PhD in finance. He teaches at the Wharton School of Business. He teaches a course on commodities futures. He's not familiar with practices in the commodities field, and he's never evaluated pure commodities portfolio, although he had evaluated other types of portfolios. And these facts are from an actual opinion, Wilkinson versus Rosenthal and Company, which is a 1989 case from the Eastern District of Pennsylvania. So again, another top hat question. What do you think? Would you find this particular business professor qualified to testify as an expert? Press pause now, go over to Top Hat and answer, and then come back for the answer. So the court in this case precluded the testimony. So despite this professor's very impressive resume and background and all of his qualifications, this witness had insufficient experience with this particular type of portfolio. Again, a different court might have come to a different conclusion. Good advocacy probably played a role in this court's ruling. Good advocacy from the opponent this time. So the defendant's lawyer had to be alert to argue that this witness, despite his many impressive qualifications and resume, could not testify expertly about this particular type of portfolio. So that leaves us with just Rule 403 in this set of hurdles under 702 that we've been talking about to introducing expert testimony. The important point to take away is that courts take 403 challenges more seriously with expert evidence than with some other types of evidence. Consider whether an expert's experience would unduly influence the jury, or would the jury be unduly confused by the expert's jargon and approach. That's something important to take into consideration because juries do tend to put a lot of heavy weight and reliance on expert testimony. So 403 is an important backup rule to think about when confronted with a 702 problem. The next chapter in your reading for today, Chapter 63, introduces us to the factual bases of expert opinions. This slide in particular is going to list 3 categories of information that experts may draw from in order to come to their conclusions. The first is personal knowledge, and this is like any other witness. Lay witnesses in particular must base their opinions on their own senses, their own perceptions, their own personal knowledge, and experts oftentimes will do the same. But here's where there's a divergence between expert and lay witnesses. Experts may rely on other evidence that was admitted during the trial to come to their conclusions. And this is unlike lay witnesses, because lay witnesses are going to be secluded or sequestered from the courtroom during the testimony of other witnesses, whereas experts can sit and listen in at trial, and then they can base their opinions on what other witnesses have said. In addition, experts can rely on otherwise inadmissible evidence, but only if other experts in the field reasonably would also rely upon the same type of inadmissible facts or data. And that's a pretty important one to keep in mind too. This is not unlike another type of witness that we've already talked about, character witnesses. So character witnesses are sort of a type of expert witness who often rely upon inadmissible evidence. So a character witness, for example, may offer her opinion of another individual's character, even though the specific acts supporting that opinion or that reputation are not admissible. Similarly, a character witness can testify about another individual's reputation, as I just said, even though the third-party statements creating that reputation are inadmissible. So character witnesses do not literally testify as experts under Rule 702, but the concept is actually very much the same. In addition to grasping an expert witness's power to rely upon different types of evidence, you must also understand a couple of things. You've got to understand first who may admit the evidence supporting an expert's opinion, and second, under what circumstances is that evidence admissible. Rule 703 and 705 combine to articulate those limits. So 703 deals with what types of information an expert may base his opinion on, and 705 complements Rule 703 by discussing the manner in which experts convey the data supporting their opinions. An expert can rely on opinions without recounting underlying facts or data, and that's under 705. So they can give a bare conclusion, or they can give a bare conclusion first and then potentially explain the underlying data. Also, an expert can offer an opinion even if the evidence supporting the opinion is inadmissible, as we've just talked about. So this next case, or this next example, I should say, is based on a recent case involving testimony of an expert historian. The case is U.S. versus Witchy, 422 F. 3rd, 479. It's a Seventh Circuit case from 2005. So this is a denaturalization case involving a man who came to the U.S. from Europe in 1950 and had gained U.S. citizenship in 1959. Authorities discovered that he had been a member of this Waffen-SS group, which was a military branch of the Nazi Party's SS organization, and he worked as a guard at a concentration camp. Now, of course, he didn't disclose this information when he first entered the United States from Europe. Under the law, the government may revoke citizenship if an applicant concealed an association with a movement that was considered hostile to the United States. So in 2003, the Department of Justice petitioned to revoke Witchy's citizenship. The key question in this case was the Waffen-SS a movement that was hostile to the United States? And to answer that question, the U.S. Introduced expert testimony of a respected historian of Nazi Germany named Johannes Tuckel. He provided information about the role of the Waffen-SS and the concentration camp where this individual worked, concluding that the Waffen-SS was in fact hostile to the United States. So he relied upon three different types of evidence. He relied upon records of German authorities from Nazi Germany, also interviews with witnesses from concentration camps, including taking their post-war statements, and also works, treatises and works of other scholars. So if you ask yourselves, what do these sources all have in common? Hopefully you figured out the answer, which is that they are all potentially inadmissible hearsay. They would not become admissible unless there's some hearsay exception that applies. So the records of a foreign government, those can qualify as public records, admissible under 803(8), but we would need to know more about these records, including the agency that made them and the purpose for which the government offered them, in order to decide their admissibility under that exception. It would be difficult to fit the post-war statements of any of these individuals into any hearsay exception. These individuals spoke to Tuckle about events they experienced or witnessed many, many years earlier. And although the works of other scholars might qualify as learned treatises under 803(18), there are limits, as you know, to the use of those treatises. So without Tuckle's testimony, the government could not have introduced much of this evidence. So this brings us to the next top hat question. Can the historian offer an opinion based on these sources? So can the expert rely upon them in formulating his opinion? You've got several options. I have 1, 2, 3, 4, but I think top hat will have A, B, C, and D. A is only if they satisfy the hearsay rule. B, yes, if experts in the field rely on them. C, yes, if experts in the field reasonably rely on them. And then finally D, no. So press pause, answer this one, and then come back for the explanation. So hopefully for this one, you identified the language straight from the rule of evidence. The answer is 3, or C. Yes, if other experts in the field reasonably rely on these sources. So like the Daubert standard, this one doesn't rely exclusively on what experts do. It's a question of what other experts in the field reasonably do. So there's sort of two different levels or layers to the judge's discretion in this case. The judge has to first make a preliminary determination about what other experts rely upon, and then second, assuming that these experts rely upon these three different sources to make determinations, the court has to then ask, are those experts who rely on this information reasonably relying on the information? Is it reasonable to rely on, for example, the treatises or witness interviews? Historians, ultimately in this case, the court found that historians reasonably rely upon all three of these kinds of sources, so the judge allowed Tuckle to submit an affidavit voicing his opinion about the role of Witchy's Guard unit during World War II. Under Rule 705, moreover, Tuckle could state his opinions without outlining all of the supporting evidence. So Tuckle's affidavit helped the government obtain summary judgment revoking Witchy's citizenship in this case. Now, if this case had gone to trial, one question would be, could Tuckle have testified on direct examination about the post-war statements of these concentration camp survivors? As you know, those statements are inadmissible hearsay, so Tuckle could have reported them only if the judge found that their probative value in helping the jury evaluate the opinion substantially outweighed their prejudicial effect. And that is taken directly from Rule 703. It's considered the reverse 403 test. And keep in mind that with this particular test, we're not just talking about or thinking about general probative value of this information, but the probative value in helping the jury evaluate the expert's opinion. So it's sort of a very specialized, specific type of probative value that the court is looking at under Rule 703 to determine whether the underlying inadmissible facts or data of an expert opinion can come in under this rule. The default, keep in mind, is that the expert may not disclose underlying facts or information that is otherwise inadmissible to the jury. What about the next question? Would Witchy have to meet the same standard to prove the evidence underlying Tuckle's testimony? So would the defendant have to meet the same standard? And the answer to that is no. Under Rule 705, an opponent may choose to explore background evidence, and there's no special test that's applied to an opponent's cross-examination of a government or of an expert witness. Finally, if the judge allowed the government to ask Tuckle about the survivor's hearsay statements, or if Witchy had probed those statements, what type of limiting instruction would the judge have given the jury? Well, the judge would have told the jury that it should use the out-of-court statements that are otherwise inadmissible hearsay only to evaluate the expert's testimony. In other words, the jury should not consider those statements for the truth of the matter asserted. But as you know by now at this point in the semester, as I often remind folks, these limiting instructions are difficult for juries to follow, and they're particularly difficult in the case of expert opinion testimony. The jury's hearing that the expert relied upon these statements to draw certain conclusions, and yet the jury's being told that they can't themselves rely on those statements for the truth of the matter, but just in evaluating the expert's testimony. It's sort of a weird and confusing limitation that most jurors probably aren't capable of fully understanding or following, but that is sort of the law's solution to some of these hearsay and evidence problems that come up in cases. Here's a different type of lawsuit. This is a picture of a Porsche. Porsche is the German auto company. It makes a car called the Cayman, shown here. Retail prices for the Cayman start around $51,000. Then there's this other company that some of you may be familiar with. I'm too familiar. I have too many of these ugly shoes. The Croc company. So the Crocs company also makes a shoe called a Cayman. Unlike the car, the Croc Cayman retails for $29.99. So Porsche sued Crocs under German law for trademark infringement. So let's just do a hypothetical. I don't have a lot of information on the actual lawsuit itself, so we'll ask some hypothetical questions about the lawsuit. So if German law is the same as the United States, right, Porsche would have to show that consumers confuse the two brands in order to show trademark infringement. So for example, that they thought that the Croc sandal was also made by the German car company, by Porsche. So to do that, Porsche will hire a company to conduct a survey. The survey company will ask consumers about their impressions of the two products. The expert will then compile the responses, do several computations, and testify in court about the percentage of consumers who confuse the two brands. So the next top hat question is, can the expert do that? Can the expert testify about the percentage of customers who think that Porsche makes sandals? So pause here, head on over to Top Hat, and then join us back for the answer. Okay, so the answer to this one is, our hypothetical is yes, C. Experts, yes, because experts reasonably rely on these survey responses. So survey responses are offered for the truth of the matter to designate whether this particular customer was confused. So they are hearsay, but the expert's allowed to base his or her opinion on inadmissible hearsay and may be able to reveal that hearsay to the jury under 703's reverse 403 test. And cross-examination outside of the court by the expert simply doesn't matter at all. And survey results, which are common in IP cases, employment cases, several other areas, are admissible because of this provision about bases of expert knowledge or opinion and the fact that it can be based on things like hearsay, right? That's a part of the survey responses. So several types of other experts base their opinions on survey responses, and those responses are inadmissible hearsay, right? Each respondent to a survey makes the out-of-court statement. The surveyor reports the statement for the truth of the matter asserted. But as I've mentioned now, an expert may rely upon these hearsay responses to draw conclusions as long as other experts in the field reasonably rely on this type of evidence. So as in the previous example, the proponent of the survey evidence may ask the expert to reveal the underlying data by satisfying Rule 703's reverse 403 test. And then the opponent, on the other hand, can ask about the underlying data on cross without satisfying any particular test. But bear in mind, as you saw from your reading in the Kids R Us case on page, I believe it was page 826, a judge may reject an expert's opinion based on a marketing survey if she finds that the survey relies upon untrustworthy data or the data fails to comply with standards observed by other experts. So again, this is just not, it's not an automatic that all survey results can come in. The survey results still have to be reliable and trustworthy and comply with standards observed by other experts. Here's another example. This is a cocaine prosecution. This is based on a case from the 7th Circuit, U.S. versus Moon. For anyone interested, it's at 512 F. 3rd, 359. And this case predated the Williams case that we talked about. I believe it was last time, but I'm going to sort of change the facts, update them with the Supreme Court's jurisprudence in order to inform our analysis of the issues that came up in Moon. So George Moon was charged with distributing cocaine. There is a DEA chemist, Ragnar Olson, who analyzed the substance that was seized from Moon and concluded it was cocaine. But then Olson left for law school, and his colleague James Francesco testified. DeFrancesco qualified as an expert and offered the opinion that the substance seized from Moon was in fact cocaine. So then the question is, what were the bases of DeFrancesco's opinion? And the answer is he had 4 different sources for his opinion that the substance was cocaine. First, he relied upon results of an infrared spectrometer. These are machine-generated results that Olson had obtained, suggesting that the substance was cocaine. Next, he relied upon the results of a gas chromatography. Like the infrared spectrometer, this is a machine analysis. With both of these, the original analyst, Olson, prepared material and put it in a machine, and the machine then produced readouts that look like this, and then the analyst who's trained in reading the readouts compares these patterns to known samples and can determine based on that, the nature of the substance. The third thing that DeFrancesco relied upon were Olson's, which is the original analyst, his lab notes found in his lab notebook, which recorded initial settings on the machine, the quantities placed into the machine, the times, etc. So from these, DeFrancesco concluded that Olson ran the previous two tests in the correct way. The fourth and final piece of evidence that DeFrancesco relied upon was a sworn report from Olson giving his conclusion that the substance was cocaine. And as you'll see, if you look closely at this report, it looks pretty similar to the affidavit that was submitted in the Melendez-Diaz case that we studied. So as we've already seen, DeFrancesco can offer his opinion based on these materials as long as, one, he's qualified as an expert, which I've told you he is, and then two, experts in his field would also reasonably rely upon this type of evidence. But the government may want to go a step further. The government may not want to rely solely upon DeFrancesco's bare opinion. It may want him to discuss some of the facts that underlie and support his opinion, and it may even want to introduce into evidence for the jury to examine on its own some of this underlying evidence. So that brings us to our first top hat question on this fact pattern. Can the government introduce the machine readouts? You have four options. Head over to Top Hat to answer this one and then return for my analysis. Okay, so the answer to this one is yes, the government can introduce the machine readouts. So 4 or D, there's no rule limits on the introduction of, there's no rule limiting the introduction to the expert reading the results into the record, right? So the expert can do that because the readouts themselves are independently admissible. So the jury can consider them for the truth of the matter asserted. If you'll recall, when we first talked about hearsay, we talked about, what constitutes a statement. And one thing that you learned is that a statement is a verbal or other type of assertion. It doesn't have to be verbal. It can be nonverbal, but it has to come from a human, right? So something that is purely machine generated is not going to fit within that definition of a verbal or nonverbal assertion made by a human being. What about Olson's sworn report? So here's the sworn report again. Take a quick look at that. And remember, Olson is not on the stand. He's not testifying. Now you've got a different person from the lab who is qualified as an expert who wants to talk about and possibly introduce someone else's report to the jury. So first, let's take a look at whether the report fits within any hearsay exception, because we know that it would otherwise be hearsay. So take a look. You've got four options on Top Hat, and come back in a moment and I can tell you the answer. The answer to this one is no, it doesn't fit within any hearsay exception. I gave you a couple different options. First was recorded recollection, and that won't work because Olson is not there. So recorded recollection was one of those hearsay exceptions that actually required the witness whose recollection is somehow recorded to be on the witness stand testifying at the time. So that won't work. The public record exception also will not work because the report stems from an investigation, a law enforcement investigation, and it's offered against the defendant. So it will not fit within that exception for that reason. Finally, present sense impression doesn't work because this isn't a contemporaneous recording of Olson's perceptions like his notes in his lab notebook might be. It's a formal summary of his findings that's created after the fact. Your next question, under 703, can DeFrancesco disclose this report to the jury? So we know now that the report is hearsay and it doesn't fit within any hearsay exception. Despite that, will Rule 703 allow this particular expert to disclose the report to the jury? Take a moment to answer this one and then come back. Great, so the answer to this one is yes, number 2 or B, letter B. Yes, if probative value substantially outweighs the prejudicial effect of the report. So it's not enough that DeFrancesco qualifies as an expert, but the court must make this specialized finding under Rule 703, the reverse 403 test that I've mentioned a few times now. So this is, keep in mind that this question that I'm asking you right now, because I feel like students can get this mixed up and it's easy to get this mixed up, is different from what we talked about last time, or it might have been actually the class before, where we talked about the confrontation clause and I introduced you to Melendez-Diaz and Bullcoming. This situation is different from those two cases because in those two cases the question was, does the expert's report come in for the truth of the matter asserted? In this case, remember under 703, the report is not coming in for the truth of the matter asserted. It's coming in simply for the jury to evaluate the expert opinion, right? So it's not hearsay in that regard. And Melendez-Diaz and Bullcoming, of course, dealt with the confrontation clause, which is a slightly different question than what we're dealing with purely under Rule 703, but there is sort of an underlying confrontation clause issue lurking that we'll talk about in a moment. So let's talk for a minute about this evidence supporting expert opinion. So in theory, in this hypothetical, the jury will use Olson's report, the one that was on your previous screen, only to evaluate DeFrancesco's opinion. And this table shows the different uses of evidence depending on whether it's admitted independently or solely under Rule 703. If it's independently admissible, it could come in not just to evaluate the expert's opinion, but also for the truth of the matter asserted. But if it's admissible only under 703, the jury is going to be given a limiting instruction that they cannot consider this report for its truth. And remember, the truth is important, right? Because the report says the substance is cocaine. The jury is going to be told they can't consider that evidence as truth, that the substance in question was cocaine, but only to evaluate DeFrancesco's opinion, although it's sort of strange because his opinion is that the stuff is cocaine. But in any regard, the report in this example is only coming in for that limited purpose, and the court is going to, of course, give a limiting instruction. So when an expert witness testifies about inadmissible data underlying her opinion, the judge is going to give an instruction reminding the jury about what they can use the report for. These instructions are one answer to both the confrontation clause issues that we've talked about and any sort of policy issues, but there's an underlying question about whether the answer is sound. Limiting instructions applied to the evidence underlying an expert's opinion in particular can be even more artificial than other limiting instructions. So imagine, for example, a limiting instruction in this case. If the court concluded that the original agent's statement, i.e. the substance is cocaine, was hearsay, as it seems that it was, the court could have instructed the jury to consider that evidence only to evaluate the worth of the courtroom expert DeFrancesco's opinion. But as I mentioned, the courtroom expert's opinion was the substance recovered from the defendant was cocaine. So how can one possibly use the underlying evidence to evaluate the worth of that opinion without also using the underlying evidence for the truth of the matter asserted? that raises sort of a broader policy question. Do Rules 703 and 705 push limiting instructions past their breaking point? And depending on who you ask, different judges and scholars have different thoughts on that question. So as I promised, let's get to this thorny issue about the introduction of Olson's report, or discussion by DeFrancesco of Olson's report, and the Sixth Amendment implications to the defendant. If the court allows DeFrancesco to refer to Olson's report under Rule 703, does that violate the defendant's Confrontation Clause rights? The report is testimonial in the sense that it is identical to the report that was offered in Melendez-Diaz. So we know from that admitting the report alone, right, without having an expert talk about the report, but just trying to get the report in, would violate the Sixth Amendment if the person who prepared the report was not present and testifying on the stand. So the question is, does the, quote, expert filter satisfy the Sixth Amendment? And as you know from your reading, this is an open question on which the law appears to be evolving. The Supreme Court's opinion in Williams versus Illinois offers these confusing signals, right? A majority of the justices, including Thomas and the dissenters, rejected this type of end run around the Confrontation Clause. But in the Williams case, Thomas actually joined the other 4 justices, the plurality, to hold that the lab report in that particular case was not testimonial. And recall, I mean, that those facts were different than what we have here. In this case, Justice Thomas, or actually, I don't know about Justice Thomas, but the plurality in that case would have decided that the report here is testimonial because it did target a specific individual, right? This was a cocaine seizure case, so there was a specific suspect in mind. In Williams, the government had no suspect when the DNA analyses were run. So the facts are different. But in any case, in Williams, Thomas joined the 4 justices of the plurality to hold that the lab report in that case was not testimonial, and the discussion of the 703 issue did not constitute a holding. So just keep in mind, this is an area of the law to keep an eye on. It's evolving, and lower courts continue to struggle with this issue without the Supreme Court really offering any guidance. So that will likely change at some point in the near future. Here's one final question. What if the defendant chooses to cross-examine DeFrancesco about the evidence on which he based his opinion? So consider both the rules of evidence and the Sixth Amendment. Can the defendant do this? 3 options: take a break or pause and answer the question on top hat and return for an explanation. So the answer here is number 3, or letter C. Yes, the defendant can do this. The rules allow an opponent to ask about the materials underlying the expert's testimony. There's no special reverse 403 test or any other standard or test that applies. The Sixth Amendment, that was sort of a red herring that I threw in there on option B. The Sixth Amendment doesn't even apply, right? Because here we're talking about the criminal defendant wanting to ask questions. And the Sixth Amendment doesn't limit evidence introduced by a defendant against a prosecutor. It simply limits evidence introduced by a prosecutor against a criminal defendant. So even if we attribute this evidence to the government, the defendant would waive any Sixth Amendment objection simply by asking about it in the first place. So the final chapter in your reading for today, chapter 64, deals with limits placed upon expert and opinion testimony under this Rule 704, which deals with ultimate issue testimony. Rule 704A rejects the common law's ultimate issue bar meaning a lay or expert witness's testimony is not objectionable just because it states an opinion on an ultimate issue in the case. An ultimate issue just being something that's sort of a deciding factor for the jury on guilt or innocence, or on liability if it's a civil case. Rule 704, however, does not mean that judges routinely allow witnesses to voice opinions on these sort of ultimate issue deciding facts. As we will discuss through examples, judges remain uncomfortable with witnesses who speak directly about ultimate issues of liability. And the reason for that is because judges really don't like experts supplanting the judge's own power to declare what the law is, or more importantly, the jury's power to apply the law and the jury's role in applying the law and determining credibility issues. So Rule 701 through 703, 705, and 403 allow judges to exclude these sort of ultimate issue opinions as either unhelpful to a jury or unfairly prejudicial. Then finally, you've got 704B, which adds a special sort of poorly considered twist to this whole situation. So responding to the acquittal of John Hinckley, Congress declared that no expert in a criminal case can state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. So this language would have prevented Hinckley's experts, and I'm sure most of you know, John Hinckley was famously acquitted, I believe it was back in 1984, of the attempted assassination of President Reagan based on his defense that he was insane at the time of the criminal act. So in response to that, Congress adds the 704B language, which would have prevented Hinckley's experts from offering some of their opinions about his mental state at the time of the shooting. But this rule also impedes prosecutors from showing that defendants intended to distribute narcotics or engage in other criminal acts, or at least you would think that it would if you are applying the clear technical language of this rule. For example, in a possession with intent to distribute case, a prosecutor's expert witness, agent, police officer would not or should not be able to testify that the defendant intended to distribute a type of drug versus intended just to possess an amount of quantity of drug for personal use. But courts typically do find ways around 704 and allow experts in drug cases to testify about intent based on presence of gun, packaging material, quantity of cocaine found, etc., etc. So courts have found ways around it. They've balked at this restraint, and in some ways have pretty much construed the rule out of existence, at least as it applies in possession with intent to distribute cases. So let's work through this rule with some examples. Here is an anti-noise provision from a city code. Imagine that the city wants to prosecute a group of young undergrads who play loud music that permeates the entire neighborhood. It disturbs you, it disturbs your study group, your sleep, and among other things, the city will need to prove that the noise was unreasonably loud and or raucous and was also annoying, or at such a volume as to annoy. To establish these three elements, the prosecutor calls Roger Boyle, an electrical engineer who testifies about noise pollution. After being qualified as an expert, Boyle is going to testify to the following. In my opinion, the noise was unreasonably loud, raucous, and annoying to a person of ordinary sensibilities. So the question here is, on what ground should the defendant object to Mr. Boyle's testimony? And here's, you've got 6 different options for this one. So head on over to Top Hat, give it your best shot, and come back for an explanation. So the answer to this one is option 1, 2, 3, 4, 5, or A, B, C, D, E to count. Option E, 1 and 3, or sorry, I should have changed these slides to sort of fit with the Top Hat format. 1 and 3, or A and C would be correct. So the defendant should object under Rule 702, arguing that the testimony won't assist the jury. It's too conclusory, usurps the jury's function. They don't need to be spoon-fed the answer to liability. They should just hear the testimony and resolve it on their own. That would be a 702 objection. And then, of course, 403. There's always a fallback, a safe fallback with 403, that this is unduly prejudicial to the defendant. The reason why B is incorrect, Rule 704, is because Rule 704 actually says the opposite, right? That an expert can testify to an ultimate issue in a case, abolishing the old rigid common law approach. That is why you don't want to include 704 in your analysis. So the key point here to keep in mind is that 704, in fact, does allow opinions on ultimate issues, but good advocates sometimes can exclude these opinions under other rules. Courts don't like it when witnesses simply parrot the words of a statute or a legal standard, because it does sort of parrot the words of a statute or legal standard, because it does sort of usurp the roles and functions of both the judge and the jury. So then that sort of begs the question, how can a prosecutor better how can a prosecutor fix the testimony of the engineer in order to avoid these defense objections, or if the defense still objects, to make the testimony less objectionable in the eyes of the court? So what would you sort of coach your witness to say instead? So instead, the witness could give specifics. People find music annoying at X decibel level, and they find it outright painful at this other Y decibel level. Couched in these terms, the court might allow a more conclusory statement to complement this testimony. The witness might even be allowed to say something like, music played at this decibel level at this time of night is the type that most people find annoying. Now we're going to turn to a different type of case, the story of Charles O'Byrne, who was a former top aide to former New York Governor David Paterson. So Mr. O'Byrne had a slight tax problem. He didn't file any state or federal tax returns for several years, despite earning approximately $100,000 per year. O'Byrne's lawyer claimed to reporters that O'Byrne suffered from what's known as late filing syndrome. This is a form of depression that allegedly causes chronic procrastination in filing taxes, although it doesn't affect other areas of life. So other taxpayers have occasionally made the same claim, although you can imagine that others consider it to be a little bit silly or ridiculous, especially the press. So I don't know if O'Byrne relied upon this defense in his negotiations with the IRS, but let's suppose that he did and that a criminal trial resulted. For the IRS to obtain the most severe sanctions against a taxpayer, they must show voluntary and intentional failure to file tax returns. If the IRS proceeded against O'Byrne on that ground, O'Byrne might want to call an expert to testify about his late filing syndrome. That would be a way of arguing that he intended to file his tax returns, but his unfortunate mental health issue is what unfortunately caused the delay. So another top hat question, can an expert testify about the late filing syndrome? Although, I'll give you a little bit more information, although taxpayers occasionally assert this syndrome, the American Psychological Association, which is the official organization in the field, does not recognize it. The syndrome does not appear in the official manual of psychiatric disorders. So with that information, can O'Byrne call an expert to testify that he suffers from this, quote, late filing syndrome? Pause and head over to Top Hat to answer this one, and then we'll see how you did. Okay, so the answer to this one is maybe. So this goes back to our discussion last time about the Daubert standard and Rule 403 and how the two interact. So maybe if O'Byrne satisfies both Daubert and Rule 403, the first choice is not correct because general acceptance, as you know, no longer controls. It's just one factor in evaluating expert testimony. But judges do act as gatekeepers, so they won't automatically admit expert testimony on every subject. It has to be reliable under Daubert and Rule 403. Now, assume that the court has allowed the testimony and that Dr. Notax has been qualified as an expert. What do you think of this testimony on the screen? So Dr. Notax for the defense says that, in my expert opinion, O'Byrne intended to file his taxes. His syndrome created excessive procrastination, leading to delay, but he always intended to file his taxes. Do we think that this would be admissible under the expert rules? Think about it for a second. It's not a top hat problem, but just take a moment to reflect and look at the rule if you need to. So the answer to this is that typically, if applied, to the letter, Rule 704B would preclude this testimony. In a criminal case, an expert cannot give an opinion on whether the defendant had a mental state that is an element of the crime. Even without Rule 704B, one could ask whether this testimony is sufficiently helpful to the jury. Does it help the jury for the expert simply to parrot the legal standard, or is this something that the jury can figure out for itself after hearing and weighing credibility and all of the evidence? So a question for you all to think about then is, how would you refine Dr. Notax's testimony to make it admissible? I might coach the witness to testify that the defendant's actions were consistent with an intent to file, which is just a slight change, right? It's not a major change in the testimony or in the wording, but for whatever reason, courts have found this consistent with language to be okay, whereas stating an outright claim about a mental element is not okay. So consistent with that formulation still conveys the same message about the defendant's mental state, but courts are more willing to allow for that type of testimony. So this example illustrates why courts have found Rule 704B difficult to enforce. And again, this is similar with, this comes up a lot in drug prosecutions. Courts will routinely allow DEA agents to testify that possession of a certain quantity of drugs or other items is, quote, consistent with an intent to distribute. And you saw an example of that in your reading in the Brown case on page 841. So the next few slides, I'm going to talk about probabilities, which is the subject of your reading, sort of the latter part of your reading for today, starting, I believe, around page 845, where the court talks about expert opinions on probabilities, and in particular, the dangers of allowing probability type of evidence into trial, particularly because people just have a difficult time understanding them. Well-educated people have a difficult time understanding probabilities and statistics. Even law students, my guess is I'm going to have a few probability quiz questions for you all at the end of this lecture, and I'll see how well you do. And don't feel bad if you don't do well, because I did terribly when I had to answer these questions before I knew the answers. So here we have Linda. And let me tell you a little bit about Linda. She's 31 years old. She's single, she's outspoken, and she's very bright. She majored in philosophy in undergrad, and as a student, she was very concerned with issues of discrimination and social justice. She also participated in a number of anti-nuclear demonstrations. With that background information, which of these statements do you think is more likely to describe Linda? A, Linda is a bank teller, or B, Linda is a bank teller who is active in the feminist movement. So pause here, head on over to Top Hat, and let me know what you think. And when you return, we'll talk about it. So the statement most likely to describe Linda is the first one, that she is a bank teller. So logically, this sort of makes sense. The probability that Linda is a bank teller must be greater than the probability that she is a bank teller with these other characteristics, because the second category is simply a subset of the first. But don't feel bad if you picked the second option. A significant number of law students end up picking the second option despite how brilliant you all are. The match between these characteristics and the traits already attributed to Linda appeal strongly to our brains, and we think, oh, based on what you've told me, she must be in the feminist movement. So this example illustrates the fact that human brains think more naturally in patterns rather than probabilities. So if pieces seem to fit in a recognizable pattern, we are drawn to them. So this next one is a very simple probability question for a computer, but I would say that it stumps most law students. So the question is, how many people do you need to produce a probability of more than 50% that two of us, or two of you, share the same birthday? So yeah, give that one a try. Remember, you're not going to get points off for getting it wrong. So pause the video, give that one a try, and then return. Okay, well, this one might surprise you, but the answer is only 23 people. So, I mean, it sounds crazy, right? When I first tried this one, I thought it was much higher than that. But think about like elementary school or middle school or camp. Think about how many people shared a birthday. Inevitably, somebody in the class shared a birthday with somebody else. And these are groups that are typically in the 23-person range. So it's not that unlikely that this sort of coincidence would occur. Now try this one. Suppose that 1% of the population has some disease. We'll call it X disease. We could call it COVID right now, and that would be pretty timely. But so at any rate, it's relatively common as these, contagious diseases go if 1% of the population has it. Let's say that doctors screen all patients for this disease using a blood test that is accurate 90% of the time. And by accurate, I mean that the test is positive in 90% of those who have X, and it's negative in 90% of those who do not have X. So let's say that you get tested for the disease and your test result is positive. How worried should you be? So in other words, what is the probability that you do in fact have X disease? Go ahead and give this one a try. Between 8 at the low end, 8%, or 100% at the high end. What do you think? So this one, like the last one, might surprise you as well. The answer is only an 8% chance that you actually, in fact, have X disease, even though you've tested positive. So in order to understand why that is, let's look at. So this table illustrates why the answer is 8%. The top row illustrates the true breakdown of affliction in the population. So we know that 1% is about, or is, I should say about it, is 10 out of 1,000 people that have this disease. So you're going to have 10 people with the disease and 990 who do not have the disease. Now, for those who have the disease, the test is positive 90% of the time. So looking at that second or that middle row, the test will return 9 positives and 1 negative. So actually we should be looking at the second or middle column, not the row. So these are for folks that just have the disease. 9 are going to test positive, 1 will test negative. For those who don't have the disease, so looking at the third column, the test is also accurate 90% of the time. But because this group is so big, and it's a lot larger than the group that has the disease, that means that we will get 99 false positives, meaning 10% of this population will falsely test positive. And then we get 891 true negatives. So now look at the people who tested positive. Now look at that second row. 9 out of 108 really have the disease. So testing positive tells us something useful. You might have this disease and you should investigate further, but with these probabilities, you shouldn't actually be all that worried yet, because again, if you test positive for the disease, only 9 out of 108 actually have it. So that's how you work that. I don't know if there's any statisticians or mathematicians in the class who got this one right. If you did, good for you, because I did. I certainly got it wrong. But these three puzzles, the whole point of, you're probably asking yourselves, okay, Professor Scott, why are you talking about this? Can we get back to stuff that's going to actually be on the exam? The whole point of this is that these three puzzles represent very common probability problems, and they can affect all types of probability evidence that's used in the courtroom. And it can confuse a lot of people, even quote-unquote experts who are hired to do this kind of stuff, get it wrong time and time again. And that's why courts are learning to be more cautious with testimony that relates to probabilities. So as we saw in the reading, when it comes to the courtroom, there are at least 4 problems with probability evidence, and they're all illustrated by that Collins case discussed at pages 846 and 847. The first is that the factual foundation may be weak. So once people start throwing numbers around, those numbers take on a life of their own, and the witness and the jurors forget that the numbers need to be rooted in established facts from the case. Technical flaws can infect the calculations as well. So a common flaw is assuming that factors are independent when they are not. And this is what happened in the Collins case when the witness considered beards and mustaches as independent factors, when in fact men with a beard are more likely than non-bearded men to have a mustache. The calculations may distract the jury from conflicts in the underlying testimony. So a witness calculating probabilities will assume, for the purposes of the calculation, that the woman was blonde, rather than acknowledging that some witnesses actually thought that she had brunette hair. And that's legitimate, but the calculations often overshadow the conflicts, so the jury will forget to factor in any conflicts in the underlying testimony. And then a fourth problem is that jurors are very likely to confuse the rarity of an event with the probability of guilt. So this is analogous to the error that many students will have made in the final diagnosis problem with that contagious disease X. So for these reasons, judges should exert special gatekeeping power and authority over testimony related to probabilities, because there is a real risk, I think, of unfair prejudice in the form of the information just being misleading to the jury misinterpreting or misunderstanding the probabilities, and that unfair prejudice could substantially outweigh probative value in this area. So this is certainly an area that's ripe for 403 objection. Okay, so this is the final topic of the chapter, expert testimony on credibility. So suppose we have this witness, Walker, who testifies for the prosecution in a drug distribution case, and Walker offers his expert opinion that the substance in the defendant's briefcase was heroin, which is a pretty straightforward opinion testimony from an expert. Can the defense now offer an expert psychologist who testifies that based on her interview with Walker, her expert opinion is that Walker is untrustworthy? So typically the rules regarding expert testimony allow this. It's an opinion about a witness's trustworthiness, and it's an expert opinion, but courts are very, very reluctant to allow this type of evidence. Judges believe it's the province of the jury to assess credibility, and for that reason, judges are reluctant to, for example, admit the result of a polygraph test into trial, because the polygraph machine is essentially telling the jurors, whether to trust the witness or whether the witness is, a credible witness, and that's not, that's taking over the role of the jury. And so judges typically don't like this type of testimony for the same reasons that they don't typically like polygraph testimony, although, as you know from your reading, some circuits are now allowing this type of evidence to come in, polygraph evidence, under certain circumstances. So let's now test your ability to, we can't actually. I was going to say, if we were in class, I had a whole exercise that I really wanted to do with you all to test your ability to discern credibility, and I would have picked a couple of students to help me out with it. So I'm kind of sad because that was one of my favorite little simulations that we did last semester, so we can't do that one. But what you can do is my last slide is a video that we can't watch here in this lecture, but is of course on Top Hat, and it's an interesting one because there are certain expert witnesses who, for a living, it's their job is to try to discern whether people are lying or telling the truth. So they're essentially human lie detectors. And in fact, in the famous O.J. Simpson trial, Johnny Cochran hired a woman, I can't remember what her exact title was, but this was her job, and she helped the defense pick a jury in that case. So there are lots of videos out there online about how these experts do what they do. Psychologist Michael Shermer is executive director of the Skeptics Society, and he has a good one of these on YouTube, which is this video that's showing up on your screen. The image is showing up on your screen, not the video. And it's called Michael Shermer Tests the Polygraph and Lie Detection Part 2. So the expert in this video, I believe, is the same one who helped Johnny Cochran pick OJ's jury. And so she's good, and so she's given a task. She has to interview several people who work for this company, and certain people are told to lie in some of their interview questions, or they're told not to lie. They're told how many times to lie, and then this expert has to try to figure out what questions they lied about and which questions they told the truth about. And she doesn't even get it right all the time. She mislabels some of the statements. So it's just an interesting one to watch, and some students last semester, when I showed it, wanted to try to pause the video and figure out for themselves if the people she was interviewing were lying or telling the truth. So check it out, just a fun little exercise, see how well you do. And it just goes to show that deciphering credibility can be very difficult because humans all act sort of differently when they lie and when they tell the truth. So that wraps up today's lecture. We are down to, I believe, just one more lecture to go, and then we are all set. So as always, if you have any questions about today's lecture or about the reading for today, the reading was, you know, it was not easy. The stuff about expert witnesses and hearsay and the confrontation clause can be very confusing for students. So please, please, please reach out to me for our virtual office hours if you need, or if you're comfortable just asking a question on the discussion board, you can do that, and I will certainly answer you as soon as I see it. Okay, take care, guys, and until next time.